J. Albert Brule, and the last time I introduced him it was in a little more formal setting. I was introducing him as an expert witness in court, and we eased him comfortably into the witness box, and he was indeed a good bet on our part. There are really few people more authoritative in this field than Al Brule. And as you know, he is a partner at Blaney Pasternak and has been there since 1967, prior to which, of course, he was with National Trust, both in Ottawa and at some point in their operation in Montreal. So he became familiar with the Quebec taxation situation. He is a bencher of the Law Society. He is the director of the course in the Bar Admission course on estate administration. Of course, for many years he's lectured to this sort of a body, to the Institute of Chartered Accountants, to all sorts of similar organizations. Something I did not know, I guess his proudest accolade is he is now the vice chairman of the Liquor License Board of Ontario. His practice is really, in a way, a tale of two cities. Those of you who know him know that he flits back and forth regularly between here and Ottawa. He practices law in Ottawa, he practices law here, and it's always important, I think, when we're asking people to speak about the execution and drafting and so forth of wills, to get someone with an Ottawa base, because they probably have at some point fallen under the aegis of the great late Mr. Auguste Lemieux, who was a practitioner in Ottawa many years ago, and who doubtless influenced Al Brule. But the way Mr. Lemieux would have a will executed was as follows, and this is true. You would go in to execute your will, the blinds would be drawn, Mr. Lemieux would be gowned, there would be two black candles guttering away, there'd be a lectern like this, and the Bible would be open, and you'd be sitting there shaking in your boots, and he would read appropriate passages on death and the hereafter. Quill pen would be produced. In a shaking hand, you'd sign the will and leave with the tears streaming down and get a bill for $200. The thing. And that was in the 30s, too. We're fortunate in having Mr. Brule as our next speaker.
Thank you very much, Burke. I like the $200 part, but not the rest. I wouldn't be as impressive as Mr. Lemieux. I got off to a bad start this morning when I came in here, not missing buses like Michael, and not fair to you people over here, but someone said, "Are you going to use this lectern here?" And I looked upon it, and I said, well, it's above my height, all right, but then I was pointed out it's really a wastebasket that the papers could go down in as I finished them. So, however, for my participation today, I did a little research in the sense that it has sometimes been described as stealing the ideas of others. Now, if this is a proper description, then I'm guilty of this type of theft, because from the various seminars I attend, the periodicals that I collect, and sometimes the seminars I give, and the excellent bar admission course materials we have available to us, these have served as a basis for some of the things I'm going to say today, and have allowed me to put together the ideas I want to pass on to you. Now, not that there's very much new in this particular area of law, but I think it's a useful exercise to remind ourselves from time to time of our role as solicitors in the area of will planning and drafting, and that's what I really want to do. The new ideas and the laws have already been put to you by the previous speakers in most respects, and my hope is to be able to assist you in putting these together to render the best possible service we can to your clients. Now, again, like the other speakers, I apologize that I can't possibly cover all I would like to say in the short period that's been allotted to me, but my more complete thoughts on the subject will be included in detail in the bound text which each of you will receive. I think it's useful to just examine the underlying aspect of a will, which is really the maker's intention. Though the testator's solicitor draws the will, it's the testator who must really determine what he wants to do. He is, after all, the only one who knows his family and their needs and how he would like to see them benefit under his will. The individual, however, after consulting a solicitor, is entitled to rely on the assistance he seeks, and the courts now seem to support this position, and later I'm going to have more to say about this and the responsibility of the solicitor in this area of law. At the outset, a solicitor, when asked to assist in preparing a will, is in a position to make clear to the client the task that's involved. For so long we've heard the word simple will, that there seems to be a general understanding with the public that preparing a will is not arduous and therefore doesn't command anything more than a modest fee, other than Mr. Lemieux. Now, it's important, I think, that we clarify this position and not wait until the file is all completed to render an account that reflects the time and the experience that has been involved in preparing such a document. I have many solicitors who have asked me how the preparation of wills can be anything but a losing proposition. I tell them that at the first interview, I explain to the prospective client that there are really two approaches to the subject. The first is really similar, I suppose, to a patient who tells the medical practitioner his symptoms and a prescription is given. The client can tell you what he wishes in a will, and you can draft the document. That I don't think is satisfactory at all. The second approach might involve the medical doctor doing a complete physical checkup on the client and then taking action. And similarly, I think a solicitor must analyze an individual's assets, explain to him the various alternatives that are available to complete a planning program in the best possible manner. And then I tell the client the only difference between the various approaches is one of time, and to take more time will involve a higher cost. Now, I suggest that the extent of this cost can be reasonably estimated after a short examination of the client's assets, and given this background of what it might cost and the importance of proper planning, the more detailed assistance usually will be sought. The solicitor can then feel comfortable in devoting the time that I believe is required. The drafting of a will is really more than expressing a testator's wish in proper language. The solicitor has to be cognizant of any restrictions which might be placed upon the testator by law, and I intend to review a few of these, and with particular emphasis as to his dependents and his assets. The solicitor has to have a knowledge of our ever-changing laws, especially in the area of succession and taxes. He must be aware that beneficiaries of assets in foreign jurisdictions may in some way be handicapped with respect to the testator in Ontario. Now, unfortunately, the need for expert craftsmanship in drafting a will often becomes apparent only after it's been offered for probate. Then a poorly planned will can cause endless litigation, expense, and so frequently family bitterness. It may also result in liability for the lawyer who prepared it. Clarity in drafting is not only essential to determine what the beneficiaries take, but also an absolute necessity to enable the executors to determine their particular course of conduct in the administration of the estate. And of course, after the drafting is completed, it is necessary that there is a proper execution of the will, and this is the responsibility of the solicitor, as I wish to discuss later. And failure to complete this part of the planning can result in personal liability. Now, the solicitor in planning a will really has to have a full disclosure of the individual's assets in order to give the best advice. Some solicitors use a form on which the individual can list his assets, and perhaps to save time, he passes that out in advance and the client brings it at the first interview. Other solicitors prepare to have an informal interview and feel that they have sufficient experience to enable the assets to be discussed completely. The unfortunate part so often is that a client is nervous at times in discussing a will because some of them feel that it's done in contemplation of death, which of course it is, and they don't like to discuss this. They do so because they feel it's a necessity, and if they are at all nervous, then that is when I find they are apt to forget to bring forward certain assets that they might own. So if no form is used, it requires careful questioning by the solicitor involved. Now, whatever the approach to determining a client's assets, let me ask you if you examine any deeds he has to title properties, mortgages, insurance policies, lists of his stocks, bonds, and so on. And if not, can you feel comfortable in dealing with those assets? The main purpose of this exercise, of course, is to be certain of ownership. So many people come in and they have a residential property they've had for 20 years, and I suggest they don't know whether they own it outright, whether they hold it as tenants in common, or whether it's as joint tenants. And of course, you all know what the result is. If it's in joint tenancy, for example, it doesn't pass under the will, but passes by way of survivorship. And one can't deal properly with those assets unless you are certain as to their ownership. On the other hand, we sometimes find clients who are very loath to discuss the details of their wealth for whatever reason they so choose. I think that the solicitor involved can overcome this particular reluctance by pointing out that without the proper information, it's difficult to give any guidance with respect to tax saving without being able to discuss fully the various aspects of how the beneficiaries might benefit. And as we do so often in planning, we change the arrangements of the assets. For example, today we might find that husband and wife own a residential property in the city in joint tenancy, or tenants in common. They may own a cottage property the same way. Well, by discussing the assets and perhaps changing the ownership, we can have them each have a principal residence and avoid tax at death. Now, apart from ordinary assets, there are two other matters that are so often overlooked by solicitors in preparing to draft a document. One is the matter of powers of appointment that the individual might have that unless he is asked about them, and so often I think that if the individual is a beneficiary by way of income in an estate, it's very wise to see the document that gives him that particular life interest, or an individual is a beneficiary in a trust, the same situation applies, because by examining those documents, we sometimes find that powers of appointment exist, and these, of course, should be exercised if the individual wishes to do so. And the other aspect that is important is one of anticipated inheritances. Now, this makes a big difference. For example, an individual testator wishes to leave assets, say, to his children. Well, if they already maybe are going to benefit from grandparents or other people from documents that are already in existence, or there is a great possibility it might alter his way of leaving those assets to the same people who are going to benefit otherwise. For example, if the children were going to benefit from a grandparent outright, then he may choose only to leave them a life interest instead of giving them a great amount of money, so that those benefits can be passed on to another generation. Now, most testators readily know the people they wish to benefit, but often they're not familiar with the alternative methods of giving, such as outright bequests, life interests with or without powers of encroachment, the creation of trust funds for certain purposes, the possibility of giving trustees discretionary powers to scatter income, to encroach on the capital, and also provisions for gifts over and so on. So it becomes necessary, not only do you receive the instructions of what the individual wants to do, but I think we have a duty to explore with the testator the alternative possibility so that at least he can make a choice if one happens to suit his particular purposes. So often the solicitor doesn't enter upon the discussion of people who may be entitled to support by a deceased under our new Part 5 of the Succession Law Reform Act. Again, I think the solicitor should review with the client to ascertain if there may be any potential claims that could be made by people covered by statute but not to be included in the will. For example, an individual may be supporting a parent, and that individual could, under our new Succession Law Reform Act, perhaps be entitled to support after the testator's death. The testator may not consider this particular problem because he feels that he's going to outlive the parent, but that doesn't always happen. So at least he may wish to make some provision if the parent happens to outlive him, rather than be subjected perhaps by a potential claim against his estate. I would suggest that if you do run across one of these situations, that there is some reluctance on the part of the testator to make benefits in the will for those people who might otherwise be entitled or perhaps entitled under the statute, that you carefully document the discussion for your future protection to show that this was discussed, pointed out to him or her, and even after that there was no provision made, because so often if discussions are private between a testator and the solicitor, the family or other beneficiaries will come along and say, I know that wasn't his intention, you haven't got the instructions right, and they look to you for having committed the error. Your best protection, of course, is to have the interview documented, to make notes so that these can be produced at a later date if necessary. And this I will speak of again later when I want to touch upon malpractice. Now, finally, as to beneficiaries, one of the most common errors made is when there are gifts to charities. We have to make certain that the client has the proper name of the charity, the purpose of the gift clearly spelled out if there are any particular restrictions on how the charity is to use the proceeds, and I suppose the most common of all mistakes is that where a charity has local, provincial, and federal branches, the determination of which one is to benefit. For example, if one simply leaves to the Cancer Society $1,000, what did the testator mean? To the local branch in Toronto, to the provincial branch, or to the national organization? And I think it is up to the solicitor to have his intention clearly spelled out so that there is no problem. Now, probably the area least understood of all by a client is that of the various tax implications. And we have been hearing about some of these in the last 2 days. And the solicitor, I think, should be familiar with these, or he should offer to obtain assistance where necessary, especially if the client has any foreign assets and foreign beneficiaries. I think there is always a reluctance on the part of some solicitors when they run into a complicated situation that they hesitate to seek help from the outside, perhaps for no other reason, for fear of losing a valuable client. But they must then examine their own minds as to say, well, I'll do it the best I can, or I will get some outside help. Now, with the elimination of succession duties, there has been a false impression created, especially with the general public, that there are no more death taxes. Now, this may be true in some instances, but as you know, with dispositions and deemed dispositions under the Income Tax Act, many problems still exist and need careful planning. Some of these you've undoubtedly heard about, and planning doesn't only mean drafting the will, but can include rearranging of assets during lifetime or making gifts. Similarly, the holding and arrangement of assets is important. Formerly, a person who held assets, for example, in the United States would receive a credit for the payment of inheritance tax there against succession duties. Now, with no source available to obtain a credit, one must pay the inheritance tax with no other tax to be paid as an offset. Thus, the solicitor, I think, should make the client aware when examining his assets of this situation so that the client can decide whether or not to sell his foreign holdings. Now, if someone simply has one or two stocks, it makes little difference. Recently, we had a situation where the client had $600,000 in U.S. assets. If he were to die holding those, he would pay the U.S. Government over $200,000 and no place to get credit against those in Canada. So really what he was holding were assets worth $400,000, not $600,000. And so in pointing this out to the individual, at least he can make a decision whether he wishes to hold those, to reduce them and pay some tax, or to eliminate them completely. The whole area of tax implication in estate planning is one which the solicitor should either know or at least be able to recognize when potential problems or savings could exist. And these must be explained to the client to allow him to make a decision. I don't intend to go into those, as I said the other speakers have. One area that I do wish to just highlight, and the details are going to be produced in the more complete text, is that there are certain legal points that a solicitor must consider prior to drafting a will. Now, most of these never come to mind to an individual testator, and so it is the draftsman who has to be satisfied that no problems exist. And let me run down a few of them very quickly. The first one as to testamentary capacity. Now, testamentary capacity really is two forms. The one all we think about, of course, is mental capacity. But also we have to query whether the solicitor has testamentary capacity in the sense that he is capable of disposing of the asset he wishes to pass on. For example, suppose the individual, and we're finding more and more with people coming to this country and taking up residence here, are perhaps being left properties from abroad or have left properties there and come here. Let me illustrate. Suppose someone has a piece of real property in Italy. He comes over here, he lives here, and he says, I'd like to give that to my son. He may not, in fact, in that case, probably cannot give it to his son because the wife has the first claim if he has a wife against that particular property. In other words, in many jurisdictions, there is a restriction on freedom of testamentary capacity, both as to assets and as to beneficiaries. And if you run across something like this, then you must find out what the restriction is and explain it to the client so that after death there is no particular problem. We have to look at certain situations as to a marriage. If there is any doubt as to the validity of a testator's existing marriage, for example, an earlier foreign divorce, and so often, again, this happens with people who have come over here from especially some of the Eastern Bloc countries, come over here, they have some form of divorce that is satisfactory here, they have assets there, but as far as the law there is concerned, they are still married, and therefore their testamentary freedom is impeded. I have mentioned the legal requirements about provisions for dependents. There are certain assets that there may be restriction on alienation, be they because of applicable law in a different jurisdiction or perhaps even by personal covenant here. And consider, for example, some of the following: community of property. And it's not only in the province of Quebec where there was community of property. We have to look, as I mentioned earlier, on joint tenancies. There may be limited interest that an individual has, and that's why I like to look at the particular document, such as an estate for life for years, partnership property, joint bank accounts, corporate shares with limitations of transfer that prohibits the individual simply from giving those under his will, choses in actions, franchises, currency control, absentee ownership of property, and the list goes on. And I'll set these out for you because one has to be careful and query the liability the solicitor might have if he goes ahead and does something without having carefully considered all the problems. We get to the matter of appointment of executors. We find, again, if you have assets in some foreign jurisdictions, that there are certain requirements as to, or restrictions as to the number you might have, as to their age, and these vary in some jurisdictions between movable and immovable property. For example, some of the states in the United States, in order to pass real property, require 3 witnesses to a will. That sounds funny to us, but no more different than when we used to accept holograph wills from other provinces in Ontario to pass personalty, but not to pass realty. So one has to consider these particular items. When it comes to the matter of life insurance, there may be certain restrictions in the policy as to declarations that have been filed with the company, which might prohibit changing of beneficiaries despite the change in the Insurance Act way back in 1962. There may be problems on assignment of the policy, commutation of income payments, and so on. And again, only by looking at these particular assets can we determine whether or not what is intended in the will can be properly carried out. There are restrictions sometimes with respect to beneficiaries. We know the rules here about infants taking at 18. Other jurisdictions, they may not be able to take at 18 if you wish to benefit. Then we get into our new group of people, that the illegitimate children under the Succession Law Reform Act. Query whether or not stepchildren are considered children, the same as adopted children are. We get into the business of incompetence, beneficiaries in Iron Curtain countries, sometimes trading with enemy legislation, foreign ownership of primary resources sometimes have great restrictions as far as transfer, and these are some of the legal impediments that we come across. Then, too, we have to look at the testator's intention, particularly with respect to such things as perpetuities and accumulation periods. And finally, the actual execution of the will, that it is done properly. Now, I want to just say a word about appointment of executors, and not in the general line that we all know, and the difference if there's an outright distribution or if there is a trust will, but just a couple of points that since we've last had a general session on estate planning with the profession, one change has taken place and clarified by the courts, and that often involves solicitors, especially from the smaller communities where they are frequently appointed under the will as an executor. Now, if you find yourself in that position, there's nothing wrong with that. And if you are the only executor or the sole surviving executor, you perhaps realize that by way of devolution of executorship, that your executor takes on the administration de bonus known with will annexed, or the actual executorship, if it's an executorship, of the estate. So halfway through an estate, you may be the executor and suddenly you die. And under your will, for whatever reasons you want, you may have appointed your wife as the executrix, and you don't want to burden her with the continuing executorship of that estate, who may have been a client of yours, that may be complicated, may be well over her head, or so on. And there is now good law to the effect that a person may appoint one individual as executor of his estate and another person as executor of an estate over which he has been the executor. And I suggest that all of you should consider that seriously, and you will know where it will apply in your case. And the authority for that is a case of relaking in 1972. Now, two other areas with executors I just want to mention. One is the use of specialized executors. And I suppose the very simple illustration might be that an individual has, let's say he wants his brother to be the executor of his estate, but he happens to have a very large stamp collection or so, a very specialized asset. His brother knows nothing about stamps or anything. So instead of burdening the brother or doing the best good for his estate, it's quite possible for him to appoint someone whom he feels is an authority in this area as the executor of his stamp collection in his will. Now he gives him instructions what to do with it, to sell it, whatever instructions he wishes to leave to him. But he can deal with this particular asset, and then usually it's set right out in the document that he has paid for this a certain fee. Maybe it's a commission if he is going to sell it, and then pay the rest of the money to the principal executor. Now, we find this, I think, more and more applicable today where people have specialized assets. Art collections, another thing. A person who has large tracts of land that he may feels are proper for development, but his ordinary executor wouldn't have the idea how to go about it. So he can appoint a specialized executor in his will for certain of his particular assets. Now, another item that's creeping into our system that is quite prevalent in the United States, and that is having different executors and different trustees. For example, one appoints executors to do what an executor must do in the so-called executor's year, and that is really collect the assets, pay the debts and duties, and set up the estate so that it's either distributable in whole or in part, or it's put on continuing trusts. And then when you get to the matter of continuing trusts, then you may want to appoint a permanent trustee such as a corporate organization. Now, that can result in a big saving to the estate, especially if members of the family are going to be the personal executors and not going to charge a large fee. And as one individual from a large bank in New York in this area pointed out, he said, the widow and any solicitor can fumble through the executorship. It's the management of the assets later when one has to set up an investment program that becomes important. So we sometimes find that we can have different executors from the trustees who will continue to manage for a period of time, and I wanted to point that out to you. I'm not going to spend any time at all here on dispositive provisions in wills. I have a fair bit to say about them, but I think we'll hold that back. The same with administrative provisions. These are pretty common. They're found in the textbooks. Some things I would like to say, and I will do so. The same thing with requirements re-execution. The one thing that I just want to point out, and it's surprising how many solicitors don't know it exists today, and that is that after you execute a will today, you can do an affidavit of execution immediately, rather than have to wait and find one of the witnesses after death. Now, that came about under our new Succession Law Reform Act, and it's very good practice that as soon as the will is executed, that you do an affidavit of execution immediately, file it with the original will, and then when it comes time to submit it for probate, that's one less thing you have to do by way of hunting up particular witnesses to a will, especially if they were two secretaries in a law office who are gone, or one secretary and an elder solicitor who's passed away or retired. So I want to point that out to you because I think it's just good practice and you can follow it. One other area in this line that is bad practice that I still see, and that is execution of wills in duplicate. Now, as Mike Jameson said before, even though you're doing multiple wills, the moment you execute the last will and you put in a power of revocation, you're revoking all the others. So query if you execute a copy without saying that it's made in duplicate, you haven't revoked the original. Because there really is only one will, and it's better to execute one copy only and make several true copies if you need it. The other reason is that if the original, if you had two as it were, went with the client, and you kept the second copy in your vault, and when he died he couldn't find the original, or his people couldn't find it, there's a presumption in law that if it's missing, he destroyed it and revoked it. But again, query if it's revoked if there's a second one around. So I think that is really quite bad. When it comes to holograph wills, we now have them. I think that there may be some emergency situations where you find you might be able to use one when one is expecting or anticipating death or running away or so, and there's no time on a weekend to get a proper document typed or so on. You might even be able to give instructions to the individual to put it in his handwriting and sign it, so at least he is covered for the immediate point. And again, query the position of a stationer's form as being or not being a valid holograph will. Now, our particular statute says wholly in his handwriting, but there are some other jurisdictions, Alberta is one, I believe, who have held that as long as the handwriting other than the printed form is in the individual's own hand, then it's a valid holograph will. But I wouldn't attempt that. Now, two or three things on executor and trustee provisions. First of all, selling assets to trustees. Now, as you know, without any specific power, this is not possible without getting involved with court applications and so on, and even then, you may not be successful. So I think you should explore with the testator whether or not there is a possibility that the individual executors may wish to be able to acquire some assets of the deceased. Very common case, a man wants his son to be an executor of his will. At the same time, the son has shares in the family operation, and the father may wish him to acquire the shares that he's holding in his estate. Now, it's not possible for the son to buy those shares unless there is specific provision in the will allowing that to happen. And even though there is only the possibility of an executor wishing to purchase assets from the estate, and one of the common areas is personal and household goods, then it is good practice to recognize that possibility might exist and allow the individual to purchase dealing at arm's length and so on. You'll find lots of precedents for it, but it should be brought up. Now, the remuneration for services performed by the trustee often involves more than normal compensation. For example, an individual who has to step in and look after a business would be one. Now, a testator should spell out the nature of such remuneration if he intends that it be other than that would be normally granted by a court or covered by a tariff. And this can be done very easily in the document. Today, with our complicated income tax provisions, it's not at all uncommon to allow the executors to employ professional help and that they be remunerated out of the estate. Basically speaking, if the executor employs someone that would normally be his responsibility, then the payment for that employment should come out of the individual executor's compensation. And there are certain, I don't suggest that you do this regularly to avoid your responsibility, because the court under the Trustee Act could recognize this, I think, and set your compensation accordingly. But there are instances where this does have application, and I suggest that if it appears that it would come into play, that it should go in the will. Now, as to use of language in wills, you'll get that in the note. I have quite a bit to say about the creeping conditions in our system of using mechanical aids, and such as computer word processing systems and so on, that have application in some offices, mag card typewriters and so on, and the use of paralegals in this particular area. I can't touch upon it now, but there's a lot of it that will be in your particular notes. I want to mention a couple of pitfalls. First one being class gifts. Now, the last time we did a series here on estate planning goes all the way back some 23 years ago to 1957, and one of the leading speakers at that time was Terrance. And if you want to have a good background on class gifts, as they then were, there are a few changes you'll easily recognize. I suggest that you look at that particular lecture. The other area I want to mention is trying to avoid general class gifts in wills because of the provisions of the Succession Law Reform Act. For example, I say I give the residue to my nieces and nephews. Now, with that particular situation, and if they are not defined as such, the administrator has to make the necessary searches, you probably heard with the Registrar General, to make sure that there are no illegitimate children of brothers and sisters who fit into that class. So it's much better to name them if they're not too numerous, or to insert a clause in your will saying that no illegitimate children of any of the beneficiaries or potential beneficiaries would fit in and qualify to take under the will. I want to mention quickly lapse and redemption, only from the point of view that while it is common, one should offer the testator a choice of what to do. For example, I leave my friend John $1,000. Now, John is young, the testator said he's going to survive, but we have to say if he doesn't survive, what's to happen? Does he want John's wife or children to get that $1,000? And at least I think you owe him the duty to let him make that decision. If he doesn't want him to have it, then we should simply say to John, if he survives me, $1,000, and there's no doubt. The same with redemption. Give John my gold watch. Today, with the price of gold, a lot of people are selling their gold watches. There may not be one there when the testator dies. And I think, again, you say to the individual, do you want him to have something else if that isn't there? Now, the gold watch is simple, but it may be my cottage I want somebody to have, and that may not be there. So at least if the testator thinks enough of an individual to give him some prized personal possession or something valuable such as a cottage, he should at least have the opportunity to recognize that that gift may deem, and he may wish to substitute something else. As to gift to infants, I'll check those in my notes. One of the big things that I find often is partial intestacy. People will make gifts of capital at certain ages and forget to give the income in between times. They'll make a gift of residue. There's no one there to take the residue, and there's no gift over. Again, we'll talk about that. But I want to spend a couple of minutes, if I just may, Mr. Doran, on the avoidance of malpractice in this area of wills. Now, unfortunately, this is becoming really prevalent. As chairman of the Practice and Insurance Committee for the Law Society, I'm seeing many instances that don't even get reported because they get corrected or settlements are made that involve malpractice in this particular area. In addition, I've counted some 38 cases in various jurisdictions during the past couple of years. Now, for some background, let me refer you to two articles on the subject that I think are worth reading. The one is by Mary Louise Dixon in the CCH publication Current Estate Planning, and one is by Rodney Hull in the Estates and Trusts Quarterly, the December 79 edition, which is entitled The Avoidance of Malpractice in Estate Planning and Administration. Now, this comes into certain areas. First of all, as to taking instructions. As I mentioned before, the legal limitations. If the lawyer misses some of those or has had knowledge of assets and then doesn't draft the will proper, is he guilty? I think the best thing to do, as I said, to avoid malpractice is to keep notes of the instructions you receive so that when these are transferred to the will, at least you can put them together, and especially notes of things that the testator doesn't want to do, that you may have advised them that he should do, such as support for dependents. And again, one must examine documents. Taking instructions secondhand is a really bad practice. It may be permissible in some cases, but if you take the instructions secondhand, for example, a husband comes in, does what he said, I want you to do my wife a will doing this, this, and this, perhaps all to him. I think that's permissible, providing that you see and go over in detail and make sure that the widow, or not the widow, the wife in that case, understands those particular things. The widow, it's pretty tough, he gets it. Now, carrying out the testator's instructions, one has to make sure that you not only get the instructions, but they're carried out properly. And if they're not carried out properly, then you could be at fault. I like to think that you go over the will after it's drafted, very detailed, not simply say come in and sign it, it's ready. Go over in detail, make sure he understands it, make sure he's got what he wishes in it. As a matter of fact, one solicitor told me, to protect himself, that he takes the original, has it signed, and on the true copy he has the particular testator acknowledge that this contains exactly what I wish as to the disposition of my assets. Just a provision and a little protection maybe. Now, as to have a will properly executed, there has been a new case in the English Chancery Division, and it would appear that based on that particular case, the courts are determined to widen the exposure of lawyers involved in estate and will planning. This is a case of Ross versus Conters, and in that case, a lawyer sent out a will to a client to be executed, and the will was returned to the lawyer. The lawyer didn't attend for the purpose of execution, nor did he send the client any detailed instructions. The will was not executed in proper fashion because a spouse of a beneficiary witnessed the will, and in England that, of course, as it was here before our new statute, was not at all permissible. Now, the intended beneficiary brought an action against the lawyer, and the court found the lawyer to be negligent and awarded the plaintiff the amount she would have received had the gift been valid. The court specifically held that a lawyer owes a duty of care to beneficiaries, which duty requires that lawyers fully apprise the testator of the possible consequences of not complying with the requirements of formal execution. And in more general terms, and I think important, is that the solicitor was held liable even though there was no privity of contract between himself and the beneficiary. His contract was between himself and the testator. The court said that there is no longer any rule that a solicitor who is negligent in his professional work can be liable only to his client. In contract, he may be liable both to his client and to others for the tort of negligence. So planning and drafting a will should not be considered a routine task, but one which requires knowledge and skill to assist the client, discharge our responsibility, and avoid any later repercussions. Thank you.